to In Perspective, the podcast from Wilkin Chapman Rollets, where we break down the legal developments shaping modern workplaces and make them easier to understand. I'm Nicola Evans, a senior associate in the employment team, and I'm joined today by my colleague Lucy Trynka. Today's hot topic are the unfair dismissal reforms under the Employment Rights Act. So we're continuing our series on the Act. And in this episode, we're turning our attention to one of the most talked about headline-grabbing areas of reform. We'll be breaking down what's changing, why it matters, and how organisations can prepare. So grab a coffee and let's put the Employment Rights Act and the new unfair dismissal regime in perspective. Hi Lucy, do you want to talk about the unfair dismissal regime that we have at the moment?
Yes, so currently, in order to bring a claim for unfair dismissal against an employer, an employee has to have been employed for 2 years, and they can bring a claim for unfair dismissal if they believe that either there wasn't a fair reason for their dismissal or that the employer didn't follow a fair and proper process. So the 5 reasons, or potentially fair reasons for dismissal, will stay the same. They're set out in legislation, so conduct, capability, redundancy, illegality, and some other substantial reason. And there'll still be the obligation to follow full and fair, proper processes. As I've said, that's currently once the employee has more than 2 years' service. And if an employee did bring such a claim against their employer, they would be entitled to compensation if that claim was successful. So currently that's the basic award, which is calculated in the same way as a redundancy payment or a statutory redundancy payment. And they would also be entitled to a compensatory award. So that compensatory award is subject to mitigation of loss. So it's based on ongoing financial losses. And right now there's a cap on what can be awarded there. So it's a cap of up to a year's salary, or kind of a statutory cap that's set by the government and reviewed each year. I think this year it was around £118,000. So up until someone reaches that 2-year point, in theory, that employee could be dismissed for any reason, as long as it's not discriminatory or linked to whistleblowing, for example. But in theory, if it's just the fact that they've committed some act of misconduct, or they're just not performing, or even if they're not a right fit for the company, in theory, up to 2 years, you could just dismiss them on that basis, and they wouldn't have any legal recourse to bring a claim against the employer. We know that doesn't always kind of pan out. However, that is the theoretical kind of legal basis behind it.
And we advise our clients on that basis, don't we? So these changes are actually going to have a fundamental effect on the advice that we give.
Yes, we still say employers should be making the most of using probationary periods in any case. However, currently we do see that some employers use them well, some don't use them as well, and they can be kind of more of a loose concept. They can go on for longer than you think, or people aren't really sure if they passed or when they came out of that probationary period. I think the most common is now either 3 to 6 months. However, I mean, you're going to tell us, but moving forwards, that's probably going to have to change.
Yes, I would say so. So shall we move on to what the changes actually are? So there's been an awful lot of media discussion surrounding the or what will be the qualifying period to bring an unfair dismissal claim. Originally, when the Act was first published, it was one of the Labour government's headline promises was to remove any qualifying length of service criteria. But as our listeners and our clients may well be aware, if you've been following the progress of the Act, there was a lot of toing and froing in the House of Lords, and the government did do a U-turn at the 11th hour due to a number of defeats by the House of Lords to not to pursue with having no qualifying period, but they have stuck with a 6 months qualifying period to bring a claim for unfair dismissal. And that's what will take effect in January 2027. So the qualifying period has been 6 months previously. It was 6 months, fun fact, it was 6 months in 1971 when the claim for unfair dismissal could first be introduced. And it's varied over the years to settle in at 2 years in 2012. So for the last 14 years, it's been 2 years. And as I say, as of January 2027, it will be 6 months. Now, why are we telling you about this now, so far in advance? For a couple of reasons. Changes do need to be made, and January 2027 is soon going to come around. But also because of the fact that any employee who is employed after July 2026 will have the required length of service come January 2027 to bring that claim. So in reality, I think we need to be telling our clients to make the changes a bit earlier. Would you agree?
Yeah, I agree. And it's quite scary to think that someone who's got 6 months service, it goes in the blink of an eye, and someone who had 6 months service now would almost be seen as a new hire that's about to be told whether they've passed their probationary period or not. However, moving forward, obviously the risk is going to go massively up for employers in respect of these new joiners. And so that's why it's important that you really need to be making use or proper use of probationary periods, discussing performance issues earlier, perhaps scheduling monthly check-ins with those employees, with new joiners, going through what is expected of them, if they are meeting them, how they can improve. Things like this, just it's going to be a much more documented and kind of in-depth process, which might sound stressful to an employer. However, in theory, it's what we would be encouraging most employers to be doing now anyway. It just might be condensed into a shorter period of time, but it's just making sure you've really made the most of those probation periods and discussed any potential issues at the earliest of stages, so that people know if they're not performing or if something is going wrong, so that they have a chance to fix it, and so that they're not shocked when it comes to a point, if and when kind of they do pass or not pass their probation period.
I completely agree with you. I think currently we see a lot of employers who let their new starters settle in. And perhaps, it's the 18 months to 2 year period whereby they really look at performance. So our advice to our listeners and to our clients is that this needs to be brought way forward, doesn't it? So probationary reviews, measuring performance. I think employers are going to have to consider what the best ways to measure performance are. I mean, it's not always an easy thing to do, particularly for new starters, when new starters are learning systems and they're learning how an organisation operates. So a probationary period is going to become a lot more of a useful tool rather than just a period whereby performance isn't really reviewed in any significant amount of detail.
And in theory, it might actually reduce the risk of the potential unfair dismissal claims. So for when someone gets dismissed currently, and it's kind of just over 2 years, and they've kind of coasted along during that 2 years, thinking everything's fine, and then 6 months later, they're dismissed on the grounds of performance, and they think, well, it's been 2.5 years, I thought I was doing fine, all my kind of appraisals, although there's been some minor issues, nothing that would make me think that I'm on the course to being dismissed.
Yeah.
Whereas these shorter periods, if you're using the probationary period correctly and you're monitoring performance and you're speaking it through every single month, you're kind of keeping in touch with them, keeping in touch on those performance objectives that you've sent and discussing any issues, it'll mean that people are more self-aware of things that they might be struggling with or the expectations that their employer has for them. And then it might be the case that if that does result in a dismissal, although no employee is ever going to be happy with it, they might think that the kind of merits of bringing a claim are going to be lower for them.
I think you're right. I think employers might be a little bit more accepting of the fact that they have been dismissed because, as we've said, the test for unfair dismissal is going to remain exactly the same. It's just the qualifying period that is going to be amended. So I think if companies utilise the probationary periods more efficiently and effectively, then I think employees are going to be potentially more accepting of decisions and therefore possibly less likely to be as aggrieved, less likely for it to come as a shock. And therefore potentially less claims. I mean, it may not play out that way, but I think it's a very interesting time for both us and our clients. I think this is a really good opportunity for companies, for employers to review their onboarding processes, review the steps that they take, strengthen them, which not only is going to protect them in future unfair dismissal claims when the qualifying period is reduced, but I think it's going to have positive effects on their workforce as a whole because, with that extra intervention early on, in my view, it's helping with the culture that the government has been talking about, trying to create throughout the process of the Act, from Bill to Act. There is an ongoing theme from the government about accountability, about a culture of openness within workplaces. So I do think there is potentially a positive effect that can come out of this. Positive culture in workplaces is a benefit. Less likely are employees going to raise grievances and complaints if they feel supported at the outset. So I do believe there are potential positives as well. I think before we forget to mention it, we should also mention the other change that's going to come into effect in January next year. And as we've said before, the unfair dismissal qualifying period, we knew about that. That was a headline. We knew about that from even before the election results were announced. But this is a development that nobody saw coming, in that as of January next year, the compensation cap that can be awarded in unfair dismissal claims is going to be removed in its entirety. What are your thoughts on that, Lucy?
Well, it's going to massively increase risk again, obviously, for employers, but financial risk particularly is one that it could be devastating for some employers if they do get a claim from someone who either struggles to get a job moving forwards, gets a lower paying job, or someone that works in a niche area where it's not as easy to find work, but they're paid a high amount. Because currently, obviously, we mentioned that it was subject to a cap of 1 year's salary or the statutory cap, which is currently about £118,000.
Yes.
However, as we said before, it's subject to mitigation of loss. So if you immediately walked into a new job, your losses were going to be limited. But even if you didn't walk into a new job and you had a year of kind of unemployment, your financial losses would be capped, and that's all you would be entitled to. So, for example, now if you're an extremely high-paying job in a niche area, for example, some kind of data or tech kind of job where you get paid high sums, but it's quite a hard area to kind of just step into a new role. They're not roles that you'd easily find, particularly at the same rate of pay. In theory, you could be getting ongoing losses for up to 2-3 years, and if that person's being paid £250,000 a year, arguably looking at £750,000 of ongoing losses. So the impact could be really, really significant. And I think a lot of employers are worrying about that because, as you said, it's not something that they saw coming. It's not something they've kind of managed to get their head around yet.
I completely agree. And quite often when I advise clients, if the situation is a situation whereby you believe somebody may bring a claim, currently we can say to a client, well, your worst case scenario is a year's salary, and that can be accounted for. It can be built into the decision-making process. Employers can consider that on a risk-based approach, knowing what the worst possible case scenario is. Now that's going to change, and it does obviously create a lot more uncertainty for clients. Obviously, we're not trying to scare clients. In my view, the removal of the compensation cap is going to have a lot more significant effect on niche areas whereby earnings are high. Perhaps the way in which settlement agreements are used and negotiated, that might change too, because again, previously you've probably found this too, Lucy, that you can put a finite cap. You can say, well, if we offer a year's salary, it's likely to be accepted because they're not going to get any more in an employment tribunal. So that's something that organisations need to start thinking about now, and to start thinking about how they will approach those conversations. Perhaps if exits of senior people is going to happen. Again, I think one of the points that we should reiterate is the fact that if, say, for example, somebody is recruited in September 2026, and you follow a bit more of an enhanced redundancy process, but you know that they aren't the right fit fairly early on, then ensure that you take steps, because come March next year, that person is going to have sufficient qualifying periods to bring that claim. So in terms of what do employers do next? I mean, have you got any specific advice that you're giving to your clients in how they can prepare for these changes to unfair dismissal?
Yeah, so I think it's always just a case of reviewing policies and procedures. Although it sounds like it's far away, January 2027 for these new changes to come in. As you've said, people that join in July, they are going to be the ones that get that enhanced protection. So it would be kind of prudent to start looking at your documents now and getting them all in order now.
Ready for July.
Ready for when that comes in, because anyone that starts in July, these are the people you're going to, or who it's going to be important that you're properly kind of reviewing performance when they start and going through those probationary periods with them. We would also advise kind of alongside your policies and procedures, looking at your actual employment contracts, making sure they're up to date, particularly looking at the length of probationary periods.
Yes.
Because if they're currently 6 months, that's just not going to be appropriate. We are probably going to start advising people to start at 3 months, with the option to extend to perhaps a month more if targets are potentially not being met and people need a little more time to be able to see if they can meet those targets. I think that would be the most appropriate
I would
length.
agree. And consistent reviews, I think is also going to be really key moving forwards.
I think diarising monthly updates or check-ins, or even sooner kind of bi-weekly check-ins with that employee after they start. Obviously, if they're performing well, you could kind of create longer check-in gaps between those check-ins. That might be appropriate. But I think you should kind of approach, as an employer, all new starters in the same way initially, in that you are kind of on it with monitoring any issues that might arise and kind of taking steps to make sure there is early intervention with those. It might not be the case that everyone needs such an in-depth probationary period. it might just be that it's something that you want to start with, as I said, and then kind of that is the safest approach for now, and that's the approach we'd recommend. But obviously, it can be tailored on a case-by-case basis.
Yeah, I would completely agree. I mean, I'm quite intrigued about whether hiring patterns are going to shift. Obviously, there's some specific sectors at the moment that may well not want to hire as many people in the run-up to these changes taking into effect, but it's happening. January 2027 is a key date, but don't put too much focus on January 2027 because all organisations do need to start looking at their policies and procedures now, ready for July. The early months of employment are going to matter more than they ever have. So I think our key takeaways are really utilise the probationary period as far as possible and ensure that those early months of employment is managed as well as possible in the circumstances.
And it's also about training line managers in advance of that to make sure that they know how the company is planning to approach these changes, how the company are going to change managing people during that probationary period, so that they know what's expected of them and what they're expected to do with these new starters. I mean, training is one of the most important things that you can be doing right now.
Absolutely. I feel like I've said that a lot recently. Update policies, train managers, cascade it to the rest of the workforce. If everybody knows what their expectations are, then I think any changes that are going to come into force under the Employment Rights Act is going to be a lot easier to manage, get your head around and comply with. Thank you, Lucy. Have you got anything else to add?
No, that's great. I think we covered everything. Thanks, Nicola.
I think we have. So thank you for listening, everybody.